Welcome to Q&A practice. Let's get a little for voice practice, and we'll start with the plaintiff. Ready? What were the gross sales for each of the two corporations for 2000? I object on the basis of relevancy. I don't know where you are going with that. I am working towards establishing, I guess, that Mr. James was in complete control of the corporation. As a result, he can manipulate the net income figure arbitrarily and essentially declare the trust or cause the trust to be ineffective, a nullity as far as the beneficiaries are concerned. The issue that was raised in your complaint is that he transferred something that had value when he was insolvent during a statutory period of time. The value at that time, if any, is controlled. If he didn't transfer anything, there is nothing to be gained. So his current status of the trust at this point in time makes no difference at all. The fact that the trust is governed by its own terms is apparent. The terms in his trust and his ability to control it would relate to the issue of a fraudulent conveyance and as to whether or not he was attempting to elude his creditors or whether, in fact, he was attempting to make an effective conveyance of some property for the benefit of his children. I would say in your statement there are 2 or 3 parts. Number 1, I think the trust speaks for itself as to what it is intended to do and how it was intended to do it. As to the creditors, the only thing the creditors could be concerned with would be whether he conveyed something that they could have reached, whether there was something of value or something that they could have reached and they conveyed. It is our position that that was not the case. If you are saying it had earning power in the future, you are really talking in contradictory terms. If you are saying it has earning power in the future, then the creditors could reach his salary and have a garnishment of any assets that he obtained. He is not taking the money from the corporations. It could be reached by attachment or excused on a judgment. So he wouldn't be taking anything from them that wasn't otherwise available to them. I think that would bear on his evidence of his intention, which is an element of another subsection of a fraudulent conveyance section, one of the subsections of the major section that I cited involves fraudulent intent. I would think that to the extent that it was valid, or whether or not it was, for example, a sham trust, or whether or not it was attempted to be an effective transfer to his children, is going to relate to the issues of his intent and his mental state. In view of the interest of discovery, I would think that would be a reasonable question. All right, and now we'll do a little practice with our with our other transcript. And we will start with the defense. Ready? As a part of your custom and practice, going out on calls as a paramedic firefighter for the Orange County Fire Authority, do you usually carry morphine with you in case it's necessary to administer that to a particular patient? Yes. Do you know if you had morphine with you on the evening of February 18th, 2007, when you received this call about Ms. Waters' incident? Yes. And based on your training and your years of experience in this area, would the administering of morphine in a particular patient trigger a positive opiate test at a hospital during a drug screen? I wouldn't have any idea. Okay, fair enough. Now you mentioned that in this type of case, because it was a head trauma case, that as part of your custom and practice, you wouldn't administer morphine because there's potential side effects, things that could occur in a negative fashion. Is that correct? Does that make sense, or should I rephrase it? No, it does make sense. It's not a standing order for paramedics in Orange County to give morphine on this type of call. It would have to come from a base hospital physician order contacted through the base hospital by a radio patient or radio paramedic. When you say it is not a standing order, meaning you would have discretion as a treating paramedic in this type of case where head trauma is found to administer morphine if you wanted to, felt it was necessary or not. I was going to object. That misstates his. I would not be able to give morphine on this type of call. That's because without a base hospital order, and that is because a determination was made on scene that it was a head trauma case. Is that correct? And also, we're only allowed to give it standing order and isolated skeletal trauma, and this patient didn't fall into that category. I'm sorry, isolated skeletal trauma. Thank you. Have you had occasion in the past to make base hospital contact on a head trauma case to get the requisite permission to administer morphine on the scene to a head trauma patient? Not that I remember. And was there any reason in this particular case why base hospital contact was not radioed in to try to get that approval to administer morphine to Ms. Waters in this case? Objection lacks foundation. I don't know if it was or wasn't. So you don't have any information one way or the other whether that was done or not done? No, you would have to listen to the radio report that's kept on tape at the base hospital, and there is a record of such a report as a part of your custom and practice that you're aware of? Yes, there is. Now, we talked earlier a little bit about the Glasgow test that you performed on Ms. Waters. I apologize if this was asked earlier. What is the purpose of the Glasgow test from a paramedic's perspective? It helps to evaluate the patient's eye, motor, and verbal status, and the lower the number that you receive, the worse off that the patient can be, and it also gives us a gauge from when we first saw them to what has changed and which direction their status is actually traveling. And based on the numbers that we talked about earlier, the abnormal finding was in the verbal section, where a normal would be a 5 reading, whereas you found Ms. Waters to be a little lower at a 4. Is that correct? That's correct. All right, that will conclude our Q&A practice.